Modern Real Estate Practice, page 58. Figure 4, period 3. Eastman and Gross. Lot A shows Eastman and Gross, shows a house, shows some shrubbery. This is Lot B. There's a house, there's a lake, and the public road is up front. The utility company has an easement and Gross across both parcels of land for its power lines. Creating an easement. An easement is created by a written agreement between the parties that establish the easement right. The creation of an easement always involves two separate parties. One party owns the land over which the easement runs, and the other party benefits from the easement. Two other ways for an easement to be created are by means of an easement by necessity and easement by prescription. Easement by necessity. An easement that was created when an owner sells a parcel of land that has no legal access to a street or public way except over the seller's remaining land is an easement by necessity. An easement by necessity is created by court order based on the principle that owners must have the right to enter and exit their land, the right of ingress, enter, and egress, exit. They cannot be landlocked. Remember, this form of easement is called an easement by necessity. It is not merely for convenience. Easement by prescription. If the claimant has made use of another's land for a certain period of time as defined by state law, an easement by prescription or prescriptive easement may be acquired. The prescriptive period generally runs from 10 to 21 years. The claimant's use must have been continuous, non-exclusive. The owner isn't excluded from using that part of the property, and without the owner's permission, the use must be visible, open, and notorious, and the owner must have been able to learn of it. The concept of tacking provides that successful periods of continuous occupation by different parties may be combined, tacked, to reach the required total number of years necessary to establish a claim for a prescriptive easement. To tack on one person's possession to that of another, the parties must have been successors in interest, such as a deceased individual and the deceased heir, a landlord and a tenant, or a seller and a buyer. Page 59. In practice, a property is located in a state with a prescriptive period of 20 years. For the past 22 years, the neighbor to the east has driven across the property's front yard several times a day to reach her garage for a more comfortable angle. The neighbor has an easement by prescription. For 25 years, the neighbor to the west has driven across the same front yard 2 or 3 times a year to reach his property when he is in a hurry. This neighbor does not have an easement by prescription because the use was not continuous. For 15 years, the neighbor to the north parked a car on the same property next to the garage. 6 years ago, the house to the north was sold to a person who continued to park a car next to the garage of the adjoining property. Last year, the buyer acquired an easement by prescription through tacking. Terminating an easement. An easement terminates when the need no longer exists, when the owner of either the dominant or the servient tenement becomes sole owner of both properties. By the release of the right of easement to the owner of the servient tenement. By the abandonment of the easement. The intention of the parties is the determining factor, or by the non-use of a prescriptive easement. Note that an easement may not automatically terminate for these reasons. Certain legal steps may be required. Licenses. A license is a personal privilege to enter the land of another for a specific purpose. A license differs from an easement in that it can be terminated or canceled by the owner of the property. If the right to use another's property is given orally or informally, it generally is considered to be a license rather than an easement. A license ends with the death of either party or with the sale of the land. Encroachments. When a building, fence, or driveway illegally extends beyond the boundaries of the land of its owner or legal building lines, an encroachment occurs. An encroachment is usually disclosed by either a physical inspection of the property or a limited survey. If a building encroaches on adjoining land, the neighbor may be able to either recover damages or secure removal of the portion of the building that encroaches. An encroachment that exceeds the state's prescriptive period, however, may give rise to an easement by prescription. Lis pendens. A lis pendens, Latin for litigation pending, is a notice filed in the public record of a pending legal action affecting the title to or possession of property. While it does not have a physical effect on property, the lis pendens creates a cloud on the title to the property, which may prevent the property from being sold or further encumbered. Recording of a lis pendens should act as an incentive to the property owner to resolve the underlying dispute. When the matter is resolved, the party who filed the lis pendens will record a release to clear the title. If the lis pendens